now move with our next session. And that's the next session is going to be talking about emerging technologies and their increasingly important role. Now, this role could be controversial, it could be beneficial. This role could imply looking at new laws, looking at new technologies, looking at new norms. So, on that note, once again, welcome to everyone to the next session that is we are having as a part of the Legal Era's flagship 11th annual Gen Next Thought Leadership Business and Law Congress 2022. As we welcome everyone to the second week of Gen Next, as we all know, right now we have a very interesting session looking at the emerging technologies and their important role today. As you all know, friends, that this Gen Next 2022 is going to be your meeting place for India's chief lawyers, chief legal officers, the best of legal luminaries of the country. So, on that note, welcome everyone. And without further ado, let's take the panel towards the brainstorming mode. So, let me invite on the moderator for the session. We are delighted to have amongst us Anubhav Kapoor ji, Director of Legal Affairs for India. Anubhav has 27 years of experience with consistent achievements or being key member and advisor to executive management, implementing strategic business growth initiatives, managing through crisis and change, and overseeing all aspects of corporate governance with the corporate legal functions, global responsibilities, and with work experience with companies engaged in information technology, software, food, pharmaceuticals, manufacturing, engineering, amongst others. So, welcome. We are once again delighted to welcome amongst us Anand Deshpande. Anand is Director, Data Privacy and Data Protection, MasterCard. He has over 13 years of experience in the privacy domain, and during his career, he has worked as a privacy attorney as well as information security consultant. Welcome, Anand, once again. We are delighted to have amongst us Nayona Roy, Head Legal Qyuki Digital Media Private Limited. Nayona has in-house corporate counsel experience of 7 years of plus with PQE with a demonstrated history of working in law firms and a key focus on fast-moving consumer goods industry, skills in corporate litigation and corporate and regulatory management across a diverse profile in law, regulating key players of the consumer goods industry, partnering multiple business functions by strategic legal opinions on contracts, regulatory risk, engagement with regulatory bodies, amongst others. Good afternoon, greetings, and welcome, Madam Roy. We're delighted to have amongst us
so much.
thank you, welcome. Once again, we are delighted to welcome amongst us a very distinguished Lakshika Joshi, Associate General Counsel, Capgemini Americas, and Lead IP Counsel Global, Capgemini Engineering. Now, Lakshika, we all know she's a seasoned media, entertainment, sports, digital professional. She's a qualified lawyer specializing in IPR, having worked on transactions ranging from complex M&A to setting up licensing, rights management division. She has a litigation and corporate practice background too. She enjoys conducting workshops and training sessions for students and organizations on contracting, drafting, IPR. And she's also been awarded as the Star Young Achievers Award for in the past. And yes, variety and innovation are Lakshika's driving forces. Lakshika, very good afternoon. Welcome to the session. And with this, allow me to just wait for our moderator. Anubhavji is just joining. So just I will take a moment for Anubhav to join, and then we take the session forward. And yes, of course, with Nayona in the house, Lakshika in the house, it's going to be a very interesting session because with all the brainstorm, and I can see that Anubhav ji has joined amongst us. So once again, at the Gen Next 2022, time now for us to brainstorm for the session on emerging technologies and their increasingly beneficial or controversial role. That we'll get to know from you all, looking at the new laws, new norms, new insights. The moderator of the session is Anubhav Kapoor ji, Director of Legal Affairs for India, and the very distinguished panelists for the session. Anand Deshpande, Director Data Privacy and Data Protection, MasterCard. And we are delighted to have amongst us Nayona Roy, Head Legal QK Digital Media Private Limited. And we're very delighted to have amongst us the very renowned Lakshika Joshi ji. So on that note, I would request our moderator for the session to take the proceedings on from here. Anubhav ji, please.
Hi, thank you. Thank you for the kind introductions and introducing the panel. Of course, we are here this afternoon to discuss an extremely interesting topic. And I have with me two eminent ladies who come from very diversified digital background, if I can use that term. And maybe we'll have an interesting discussion. We'll leave the question answers for the end. One of our panelists, Anand Deshpande, may be joining in the middle of the session, but we'll wait for him if he could join. So without much ado, I think let me start it with a little introduction and the background so that you can and I start with the whole concept of a metaverse, right? And I think this is a buzzword that's been going on for quite some time in the technology space now. And the metaverse envisions a future in which people can use either augmented reality or virtual reality through use of different handsets, glasses, or wristbands, etc., or even fashion wear to do a variety of things, including, say, socialize, collaborate, adopt avatars, play games, explore virtual zoos, hear music, jingles, meet at virtual coffee shops, hold meetings in virtual boardrooms, dance in virtual nightclubs, and attend a virtual concert with friends, right? So there's a whole lot of new world where everything comes in virtual reality before us. And of course, if we are creating a virtual world, it will also come with its own pluses and minuses, right? So both virtual reality and augmented reality basically has been a major contribution, and metaverse has kind of emerged as one of the top 5 emerging trends and technologies for 2022, and is likely to be worth more than 800 billion industry by 2024. And that's large numbers, right, given the trend. But as the concept of metaverse is gradually unfolding and has also opened endless opportunities in both commercially and technically. But the key enablers of these trends is development in areas of internet, the 5G, the blockchain technologies, and artificial intelligence technologies, right? These are all, the advancement on these technologies has really kind of brought the entire concept of metaverse into being, right? And they are the key enablers. But as we get into this immersive digital environment of the metaverse, it also is creating a number of issues, right? Including areas of ownerships of intellectual property on virtual goods and materials, including, say, avatars, right? And when we say avatar, it is the virtual character that we so love on a video game or say on a metaverse platform produced by companies and users, and as well as enforcement of IP rights in the event of infringement. So there and other areas that are also getting affected are personal rights, and cybersecurity is another one that will become important. And but why has metaverse gained so much of attention is because higher profile companies like Meta or Facebook or Microsoft have already announced their plans to develop new metaverse platforms for both entertainment and working purposes. This is of course, stimulated a lot of industry player enthusiasm among industry players to develop ecosystems compatible with major players with metaverse visions, right? And we'll get into some use cases with the panelists, however, the regulatory landscape governing digital content and intellectual property is the primary legal regime for the governance and growth of content in the metaverse. So, because everything comes in a virtual form, right? So, however, because of that, I think there is a increased discussion among and rising concerns on the effectiveness of our existing legal regime that struggles to cope up with the once unthinkable use and dependence on technology for consumption of content, right? And therefore the digital content creators are already facing this issue. So we'll spend the next hour crystal ball gazing and with our panelists to discuss the key challenges and opportunities. Let me start first with the concept of non-fungible tokens, right, or NFTs as they are popularly called as. Many companies like Nike, Gucci, and Skechers, they have already and several other players, right, both in fashion and music industry, and have already been rushing to register trademarks for their metaverse products. Some of these companies have also explored NFTs to protect their IP rights, and the beautiful concept of NFT is not only they are present virtually, but they are auctioned along with some real world items and they are priced significantly higher, right, or the same as the real products itself, right? So there is immense commercial opportunity there. Now, NFTs also bring in some real benefits, like, for example, NFT assist the brand owners in reducing anti-counterfeiting, which is a big problem among the retailers and brand owners. But however, NFTs cannot guarantee authenticity fully, because if the information entered into the outset is false, then the NFTs will affirm and uphold that untruth or false information in subsequent sales. But NFTs can be embedded in physical products and can be scanned throughout, which really gives a protection against the counterfeiting. So, and NFTs are created by owners and of digital content in a very unique format using blockchain and smart contracts. And this is really related to protection of trademarks and the use in form of a licensing. And this probably marks the first step in creation of the real metaverse for the digital space. Now, with that background, I know it was a bit, and context setting, let me move to my first panelist, Nayona, who works in with a digital content company and a creator company, and especially deals with music. And so, Nayona, over to you. Tell me something more about NFTs, right? And what is that actually gets created and gets transferred in the in a NFT transaction?
Right. Thank you so much, sir, for that introduction and for the context setting. This has really made my work a lot easier. Hi, everyone. I'm Nayona Roy. I'm the head of legal for Qyuki Digital Media. We're a startup. We're an 11-year-old startup, which has been co-founded by late Sameer Bangara, A.R. Rahman, and Shekhar Kapoor. And apart from heading the legal team, I'm also pioneering the advent of Qyuki into the Web3 and the blockchain space. In fact, as we speak about NFTs at the recent All About Music event 2022, earlier this week, my co-author and I have launched a white paper on NFTs and created an NFT out of the same, which we dropped at the same session. So what does all of this mean then? NFTs are basically non-fungible tokens, which simplistically means that it's a token or a digital collectible like art, music, photography, etc., which cannot be exchanged at par. So if you give a rupee, you can get a rupee back. This cannot be exchanged at par. So that's the broad meaning of an NFT. Before I delve further into how this world functions, let me just give a short brief about the details of the blockchain and about the context in which NFTs have emerged. So the Web3 is founded on the blockchain technology, which is a distributed ledger technology. It is purely decentralized, and it is comprised of a number of data blocks, which are stored across a number of computers across time and space. And these are all interlinked. So therefore, a blockchain is formed. Any transaction on the blockchain involves a process of mining, which is a complex computational process that is undertaken through one of several algorithms. The two most important algorithms, and these you would have heard of because it's been in the news recently for Ethereum, are proof of work and proof of stake. This computational process is rewarded by what is called gas fees, and that's what identifies the transaction cost of an NFT. The proof of work is a more energy intensive process. It's also a more foolproof process, but it's a more energy intensive process, which requires a lot of computational energy, and therefore the gas fees are significantly higher. Proof of stake, on the other hand, is a much easier process, which is less energy efficient, less energy intensive, and Ethereum claims that it is 99.95% more energy efficient. Without getting too much into the technicalities of these, how do these transactions actually happen? These transactions happen through what we call smart contracts. Now, this is not a digital version of a contract. Or it is partly so. It is actually a self-executing code that is coded into the digital artwork on the blockchain and enables transactions. It identifies points of ownership and value exchange and enables the transfer of that ownership as well. This blockchain concept was initially developed. As soon as this blockchain concept was initially developed, we found the concept of a cryptocurrency, Bitcoin being the first cryptocurrency coming into the picture. While Bitcoin was based on the proof of work algorithm and, of course, more expensive, more energy intensive, a number of cryptocurrencies have emerged today on various other chains and platforms. So today we have a wide variety. The gas fees are also significantly variant. At a time when the market was actually bullish, the gas fees were varying from the Ethereum chain, which was a proof of work system, from 75 USD to something like around a 0.0026, 0.00016 USD in the proof of stake systems. So this is around December 2021. And so this is how the transactions actually function. Now, of course, with a new range of transactions, a new range of assets have also come into the picture. These assets are what we call NFTs. They are digital assets that are created on the blockchain that are transacted via smart contracts using cryptocurrency, primarily. I'm not saying that you can't exchange NFTs through fiat currency. Fan Tiger, for example, permits that, but it is generally exchanged by way of cryptocurrency. So where the question that arises is, where do NFTs really derive their value from? Because as Sir just mentioned, we have abnormal figures going for NFTs. Jack Dorsey's first tweet sold for $2.9 million. Beeple, which was one of the most famous NFT collections, Beeple's first 5,000 days artwork collection, launched for $69.3 million. So the question is, where do NFTs derive their value from? it is, of course, a perceived value, and it is a value which a lot of people think are because of a fad. But as I mentioned, a lot of brands are getting into the space. A lot of brands are trying to monetize the space, and that's why I am pioneering this technology for my company as well. We are into creators, we are into creator economy, and a great way of monetizing content is through the Web3 space because it enables royalty payouts, it protects their IP in a different way. It's definitely a very novel monetization mechanism. But art in its original form, in its conventional form, derived its value from critical acknowledgement, the historical cultural ecosystem in which it existed, rarity, originality, all of that. NFTs, by attempting to tokenize art, and when I say tokenize, it's because there's a process called minting of an NFT. Every NFT is converted into, every piece of art or a digital form of art is converted into a token and listed on the marketplace, and that process is called minting. So when an NFT is minted, one school of thought feels that it is actually liberating contemporary art. It's giving proprietary and ownership rights to digital and small creators. The other school of thought, and an example of that is Meta Worlds Berlin, right? It's a 48-meter tall virtual tower created in Berlin to create NFTs out of the street art. So it's enabling street artists to actually make money out of their work. So that's a beautiful concept. At the same time, there are also people who feel that NFTs are stripping art of its historical cultural ethos and background, and it is nothing but a financial instrument of profitability. Now, whichever school of thought you belong to, or whichever school of thought you transition to, it's undeniable that NFTs have infused into the system of digital art, which was earlier just downloadable on any device, proprietary rights, ownership rights. And these ownership rights are what are transferred by way of smart contracts. These are not owned by a centralized authority. Cryptocurrency is not backed by an intrinsic value. These are completely decentralized. You can say it is even a parallel. I mean, I would be probably presumptuous to say this, but it's actually quite like a parallel economy. The debate continues. It is far from being set to rest. But NFTs derive their value from a number of things. As Sir mentioned, it's a blurring of lines between physical and digital worlds. So, for example, the Bored Ape Yacht Club, which was one of the most famous NFT collections, again, had digital ape images, and they not only allowed access to online game and chat rooms, etc., but they allowed monetization and ownership of the IP rights in the underlying artwork. So you could create derivative artworks, brands started using them as logos, celebrities used them as DPs on their social media accounts, merchandising was created. It even included the access to an exclusive yacht party. So anything exclusive sells, right? We are in that age where anything exclusive sells. So this is one very key example. Another is DAOs, decentralized autonomous organizations, where a number of people who have a shared objective come together to and pool in their resources for that objective. And it is governed by democratic voting rights of the token holders. Very interestingly, in November 2021, we saw the Constitution DAO coming in the US. They actually tried to get collective ownership over a digital version of the US Constitution. And guess how much they managed to raise? $47 million, and yet lost in Sotheby's auction. So that's the kind of numbers we look at when we look at NFTs. And that's the scale at which it's growing. There is no limit to this world. There is no limit to this universe, which might, of course, be scary, but it's also incredible and also incredibly inspiring. So I think it derives its value from the credibility and value of the brand and the institution that it is representing. the scarcity and the communal patronage. But communal patronage is not something that comes easy. And who knows that more than me, because I work for the digital creator economy, and to get a creator to increase their following and to market them the right way is a tedious task, right? So to market something that feels out of the world, like NFTs, is of course not easy. But as I said, the communal patronage comes from the brand that you're representing, the institution you're representing. It comes from the scarcity of its value. It comes from putting a face to the name, because you don't want to deal with numbers and codes and weird acronyms, right? The challenges come in terms of the high transaction costs, in terms of the lack of knowledge, which my co-author Rafael Pereira and I sought to contribute in our small way to overcoming through our white paper. It comes because of the lack of regulatory clarity, because I think this is the first time in this budget that we got recognition for NFTs, and yet there is a lot of ambiguity in the regulatory and legislative space, which is still being figured out. But increasingly, we can definitely see more and more clients, more and more creators showing interest in this space, wanting to use this space, and wanting to create DAOs. Collective ownership and fractionalization has really helped, because you don't really need to own an entire NFT. You can actually own just a fraction of it. Also, I think what's happening is that initially the market was absolutely uncontrollable, but now more and more NFT collections are coming up, which are much cheaper, which are promoted by a particular artist and are more affordable. And therefore, the accessibility of masses is also proportionately increasing. So, yes, I think, and of course, the value is that just like foreign exchange, right? The value has an equivalent value in fiat currency, because even when you're transacting in an NFT, in a smart contract, you have to create a MetaMask wallet on your blockchain platform. And you have to first convert fiat currency into cryptocurrency, and then again cryptocurrency into fiat currency to realize the value once the sale is completed. So it's not that it has absolutely no value in fiat currency. So yes, that's the long and short of it. The rights mechanism is an extremely important part of NFTs, and there are a number of use cases in this as well.
Thank you, Nayona, for deep diving into the subject. But I have one brief follow-on question for you. How do you protect the NFTs, right? I think one of the challenges which many companies are struggling with is that many of these trademarks are non-traditional, right? They're either moving images or sound marks, and of course, there are two parts of every digital content. One is the device, and the other is, of course, the content that you are creating, right? Traditionally, software, probably we had a lot of discussions in terms of patenting softwares and things like that. But just to, as a beginner, can you help us understand which classifications you use to protect NFTs?
Sure, sir. So the most important thing I would say, even before I delve into that question, the question is, as lawyers, we are often faced with a question that when I'm buying an NFT, what am I buying? The transfer of ownership of an NFT does not mean the transfer of ownership of the underlying asset. It is completely dependent on the terms of sale that are coded into the smart contract, right? At the end of the day, it is, yeah, so it's coded into the smart contract. So I gave you an example of the Bored Ape Yacht Club, where the IP in the underlying asset of that digital artwork, the copyright, was transferred, and you could create derivative works out of it. That is fed into the smart contract. There's a contrary example as well. The NBA Top Shots, the National Basketball League of the US, They created NFTs out of moments, which were match highlights. They were short 2-3 second clips. They transferred only a right to monetize the NFT as a virtual asset. So you could sell the NFT against a price to another person, but the rights and the underlying asset could not be changed, could not be transferred. So it was just a license to use for personal purposes and for personal possession, just a snob value in the geek world, if I may say so. But you could not modify the art in it. You couldn't do any of those things. For example, there was an NFT created by Coca-Cola, which was a visual of a Coca-Cola cap, and it's just a red cap with the Coca-Cola logo on it. Obviously, you're not transferring the rights in the logo. The rights in the underlying asset, which are the trademarks or the copyright, remain as it is. This is a virtual asset. I'm not even saying it's a derivative. It is a virtual asset that is created by procuring the rights of creation from the rights holder or by the rights holder themselves. And it is encoded into the NFT. Now, when I'm selling my white paper, for example, or I'm not selling it, I'm giving it for free. Whenever a user mints it, they are downloading an unlockable version of it. So they can read it. They can't modify it. If they choose to sell it, then yes, my royalty is fed into the smart contract. So that's the most beautiful part. Earlier, artists had to fight for royalty. They had to fight for establishment of their copyright. Today, it's coded into a smart contract. The minute the funds are getting disbursed, the portion of my royalty comes into my wallet automatically. It doesn't get routed through any other party. That's the most beautiful part of this. But yet, I will not say that infringement is not happening. I mean, recently, there's a case in the US where Nike had sued an NFT maker because that guy made an NFT out of images of shoes. And Nike said that you're actually copying the design of my shoes. So it's being fought in the US Supreme Court as of now, and let's wait and watch what happens to it.
Thank you, Nayona. I think that was quite insightful, right? So people who are getting into this NFTs in the metaverse, I think there are, as Nayona said, licensing becomes an important part of it, and which basically will depend on the terms and conditions of your smart contracts, and of course there are advantages and disadvantages of that area, and one has to be careful while drafting those contracts.
And a very in-depth rights check which is required, because there are complex IPs as well that are created. So at that time, it becomes a mammoth task.
Absolutely, Nana. And of course, the second is, if you want to, you are creating trademarks in the virtual space, then of course you have to find out the right classification, because that's becoming a little tricky. Some of the classifications that probably you can that apply for metaverse products and services are class 9, which kind of has downloadable virtual goods, class 35 and class 41, which deals with online entertainment services, right? So, but there is no straightforward answer to this, right? This is still, I think, there is a discussion or thinking going on that the current classifications have to be modified to suit the products and services in the virtual world, and that's where the gray is, or the emerging legal areas are. Right. So shifting gears from Nayona to Lakshika, and we deal Lakshika with in one of the other areas that has really promoted the metaverse space or the virtual space is the development in the areas of AI. Right, and AI has been long deployed actually by the media and the big tech companies like Google, Netflix, Microsoft, Amazon, IBM, you name it, and they have been using AI to help them enforce intellectual property by identifying potential violations, right? And today it is quite clear that there are companies that have entire business models which are dedicated on these technologies and capabilities as we see this area developing. In one of the blogs, companies like IBM have used AI for literally everything, for customer care, advanced cloud and network searches, cyber security. But and however, AI can be targeted to find intellectual property violations. For example, in AI algorithm can be set to scan for unauthorized use of video, images, or other digital assets, right? And the same AI can also be used to determine what sort of monetization the violator of the property has engaged in, and so on and so forth. So the key question remains is how is AI can be deployed in the metaverse to enforce the protection of intellectual property, and can it also be used along with other technologies like blockchain? What are the legal issues that you see in AI at this point of time?
Thanks, Anubhav, and thank you, Nayona. That was pretty insightful. I'll probably step back a little, Anubhav, and I would want to take this as a broader question. The kind of legal issues that we see pertaining to AI are not probably convergent at a metaverse level. Those issues are looming large, whether it is AI in a digital environment or elsewhere. Those issues remain, and there are several. And the several issues actually come up because of the nature of AI. And I'm not going to get into technicalities of how AI is and how the neural networks work, but very often there's a tendency to confuse AI with machine learning, which it is definitely not. There's a very distinct difference between the two. So AI is very different from machine learning. Of course, there are data sets that AI uses to sort of, derive and conclude and, sort of imbibe into it, and for the purpose of those neural networks to sort of make sense of and draw analogies. But again, it's very different. So the way AI is and the way it is sort of the kind of challenges that it poses also spread across digital networks, metaverse, or any form of interactivity that AI has with, I would say, the human world. And some of those legal challenges are pretty interesting as well as difficult to resolve at this point in time. They are, at least the way I see them, can be put into few buckets. So there's a whole big challenge that AI poses around security and privacy issues. There is a challenge around licensing matters. How would IP and IPR licensing work in that framework? There's a third bucket of what do you do with algorithmic biases, and hence where would liabilities rest, in that systems, in AI kind of systems. And the fourth bucket that I see is of ownership, authorship, and intellectual property rights within AI. So if we were to look at slicing down each of these issues, they can be, full-fledged topics for on their own. But having said that, the first bucket of security, the more powerful this technology is becoming, or for that matter, any technology, it also can be put to nefarious uses. And we all know how humanoids have sort of come into existence. There are n number of use cases where humanoids or robots are doing everything from being news readers and broadcasters to being granted citizenship, by governments in Saudi Arabia, to, doing so many things like being mounted on drones for surveillance, or also being used by judiciary for granting pre-trial bails, and so on and so forth. So when we put AI to all of these kinds of use, and AI is not something that we don't deal with. You and I, the minute we type something on Google search, even before we can complete the a word, a phrase will pop up on its own, because that's AI at work, almost predicting for you that is it what you want to search, or they will auto spell and things like those. Simplest of things, all of that is AI. It's just getting evolved. We've had instances where in Scotland during a soccer game, and it's a very interesting video. I'm sure many of you have already watched it over YouTube, that AI camera mistakes a linesman's head for a ball. And just because the linesman was bald, instead of tracking the ball, it goes all the way and tracks the person's head. We've had, serious issues around recruiting tools showing a bias towards a gender. And one of the world's famous online aggregator retail website deploying those kind of recruitment tools, those were of course taken off. We've had cars on autopilot, crashing and causing injury and serious damage to both property and to people. So those are issues that we've seen so far. Now, what that actually leads us to then think of is how are these going to be tackled in the long run? Because if it's the same technology which can be put to both good and nefarious uses, but I see a future where, battles and fights are not fought on battleground. We all know that, but there is so much that goes around in the cybersecurity world. And that is where we need to think of how we would be using AI systems. We've all heard of famous Clearview example, where artificial intelligence company called Clearview, it was being used to identify for enforcement agencies to identify terrorists, traffickers, pedophiles, and all. And then very recently, I think about a year and a half back, the New York Times, it reported, and there was a long story about how this Clearview artificial intelligence company was actually making a mockery of data privacy by scrapping around about 3 billion photos of users from social media platforms like Facebook, YouTube, Twitter, Insta, and so on. And, that sort of leads you to think of what about the privacy and data protection issues when we use technologies or deploy technologies such as AI. Many innocent people may fall prey to investigations which are unreasonable, unfair, and so on. So when we sort of look at this whole way this technology is posed, there are both goods and bads. Similarly, when we talk about how we deal with it in a certain platform, whether it is digital platform or metaverse, there have been instances where even without AI, there have been instances of bullying on metaverse, where a certain account or avatar had to be blacklisted because of those issues. Now you add the AI element to that. AI in itself, if you are to do a quick search on AI going rogue, you'll have more than hundreds of cases of AI going rogue. And here we are talking of a mixed reality, which is metaverse, where even without AI going rogue, there are still a lot of threats prevalent. Now you add the AI component on top of it, who knows what's going to happen. So I think these threats are really, really sort of looming large now. We need to be very careful about how to handle them. And of course, you asked about IP ownership. Those are issues that are very, very specific. Those are issues that many of the patent offices, many of the trademark offices, copyright offices across the globe have very specifically dealt with. In fact, largely the opinion has been pretty much consistent across the globe with not granting any protection to AI-generated works, because there needs to be some amount of human element into what is being generated if it needs to be registered at a certain IPO. So if we are to look at a couple of major jurisdictions like UK, EU, US, and so on, I think they've been pretty consistent with it. With, of course, exceptions of places like China. In China, we've had an article which was created by artificial intelligence program benefit from copyright protection. Similarly, in South Africa, the patent office granted patent for an invention which was conceived by an artificial intelligence. And this is a very interesting case because this matter is a matter pertaining to the same AI called Dabus, which actually filed for a patent in various jurisdictions, all the way from US to UK IPO to EU to Australia, Canada, China, and so on. And most of the IPOs actually did not grant a patent except for South Africa, where it's actually the first country that granted a patent to an inventor who's non-human. So it's very interesting. Of course, the issues around why it granted, and there's a lot of background to that South Africa is not a jurisdiction where substantive patent examinations happen, because the government doesn't evaluate on merits of the patent application before granting patent. If you've filled in the application, certain forms are met, templates are met, filing fees have been sort of taken care of, then a patent is granted. So that in itself is a different thing. But having said that, on one hand, we have jurisdictions and we have IPOs that are sort of still resisting the idea of inventorship or authorship, which is granted to a work which is solely created by AI, and they are resisting it. On the other hand, there is an interesting example where, let's say you were to sort of, and this is a real life example. I'm sure you're aware that there was a Rembrandt which was sort of recreated by an AI algorithm, and this recreated Rembrandt was sold by or auctioned at Sotheby's for several millions of dollars. Now, imagine a situation if you were to sort of buy a painting at an auction for several millions of dollars created by AI, bring it home, and then you have a neighbor come over, click a picture of it, and sort of then start commercializing or creating T-shirts or putting it out on stationery and, using it all over. What would you do? You bought the AI generated artwork for several million dollars, and now you've got someone sort of recreating and using it all over without paying any royalties, without any investments, and you can do nothing because the IPOs are not sort of recognizing the rights of AI inventorship or AI authorship. They're saying that any work which does not list a human as an author cannot be protected by intellectual property rights. So where are you then? What would you do in that situation? It's very interesting because for large organizations and companies that are investing in AI systems, it's almost a dichotomy. You would invest in AI systems for better productivity, for creating better mechanisms, processes, methods, products, and services. And those are not protected by intellectual property rights of the world as they exist. And if they're not, then are we saying that, hey, there's a great system or a great product created by AI, it is worthy of patent, but because it was an AI generated product, it couldn't be patented. So then it becomes available to public at large to sort of use, copy, create, compile, and so on. question mark, and interestingly, governments both in UK and US have been looking at it as more of a policy issue, inviting a lot of opinions from public at large to sort of answer questions around how would you want to see ownership vest, where would you want the rights to vest, how much of it should be, because the opinion is slightly sort of divided. Some of the IPOs think that, well, AI does deserve to be an inventor, but not on its own. If the application also has a human mentioned as an inventor, they would be willing to grant the IP rights. On the other hand, some of them totally do not recognize that. So, for example, in Germany, the same Dabus application said, there was a notation which said that, well, if you also had Thaler, the guy who created this Dabus AI, also mentioned as an inventor, they would have granted the patent. So if it is co-invented, then they would grant the patent. But then the question, when we talk of co-invention, would be which portion is created by. So typically in an IP scenario, when you go in for registrations and there are multiple authors or multiple inventors, you clearly sort of identify who and allocate the portions of that inventorship or authorship to a certain creator. But in this kind of a system, would you do that to AI? And then are you saying when you allocate it and there's a certain portion which is purely AI driven or AI created, will that still remain out, at large for public to copy, to simulate, to do whatever they wish to? Again, all very mixed things there, very mixed opinions, and from across the globe, not just in the country. Of course, in India, we're also facing similar issues. Because none of us across the globe have still settled where ownership should lie. Now, take all of this to a place like metaverse, where you're not even in the real world, where you're talking of avatars, where it's a mixed reality, it's a virtual reality, it's an augmented reality, and all of this put together with the kind of threats, challenges, and all the conundrum which we already are carrying from the AI systems into a metaverse environment. What do? I'm on the metaverse. I have an avatar, which is my avatar, but now I get to impose AI on my avatar. So at what point would you decide? So when there was the first bullying incidents on the metaverse, the company that actually ran that metaverse was responsible for quickly blacklisting or taking that avatar off its website and things like those, or sorry, off its metaverse and things like those. But let's say if I have an avatar and that avatar is half me and half AI, bases some data fed into it on how I would behave in a certain situation, then would you hold my avatar responsible, or would you hold that AI responsible for certain things? So then what are the sort of rights that we are looking at? And that's again a legal question that AI world poses for us. What are the rights that we will assign to AI? Will we say that AI will have liabilities? Will we say, or it'll always be the creator of AI that will be liable, which in itself is very far-fetched, because AI is not a machine which is in control of the human. It's a very deep neural network which is making its own decisions, and how it's arriving at those decisions is almost like a black box. There's not enough transparency for you to deduct how it came to that conclusion. So then how can you hold the owner of that AI responsible after a certain point in time? I may have been responsible only as much as switching on the system and feeding electric currents into the system. Rest of it, purely AI driven, making its own decisions, taking its own calls, and good, bad, whatever, ugly, doing for its own. So then who do you hold liable? Where will the criminal liabilities vest? Will you also assign certain civil rights to it? And of course, all these questions we saw when in 2017, the humanoid Sophia was granted citizenship by Saudi Arabia governments. Of course, later off, the whole robotics project was taken off. But again, that posed some of these very interesting questions. Then are we talking of rights for AI, rights for robots, and all of these will get mixed. It won't be just intellectual property rights, but all of these civil rights, all of these if I may, for lack of a better word, say human rights, or because we're already talking about building ethics into artificial intelligence. We're talking about building emotional intelligence into artificial intelligence. So once this artificial intelligence becomes emotionally intelligent, are we also going to recognize their rights? And so on and so forth. So it becomes extremely complicated, and all of this, transposed to a metaverse world. I don't know if you're equipped to even deal with those complications right now. Well, crazy. I go crazy thinking of that at times.
Thank you, Lakshika. I think you brought in so many interesting facts at this point in terms of the various complications that could arise if this whole concept develops full fold. As a follow-on question, Lakshika, tell me what is the solution for this? Do you think creating a special classification or category for AI generated IPs will solve the problem? And also, I think more and more as practitioners, we are getting into issues of jurisdiction, right? Because in a technology space, while the laws are still very much jurisdictional or place or country specific, but the usage of and the infringement cases are coming all over the world, right? You can get access everywhere. So what do you think is the possible solutions, and how do you deal with this kind of a challenge? Because for filing any case, you have to determine the jurisdiction first, right? And of course, if you are investing billions, as you are saying, then you need to protect that investment as well, right? So.
Thanks, Anubhav. That's a very good question, because it's also a very difficult question to answer. Well, I don't have any clear answer, but I'll just bring some thoughts to the fore here, and look at the intent of the laws that we have. Let's say if we and it goes for everything. It goes for criminal laws. I think the underlying principle that we look for is always mens rea. Whether there is mens rea, there is actus rea. Those are the underlying principles. If we establish that, then there is liability in criminal law, right? Similarly, in IP law, what is the intent? The intent is the whole structure across the globe for IP laws, which are jurisdictional in nature, is that they want to be able to grant exclusivity to do certain things to the creator or inventor for a limited period of time, so that they can benefit from that IP. And the reason for all of this is because they want to spur more innovation, spur more inventorship, right? Now, if it is a machine, like I say, if it is an AI, do you think granting any kind of exclusivity to that AI is incentivizing AI to create more? I don't think so. Do we even need to incentivize? So the whole purpose of the IP laws or granting an IP to a person in the work created by the person is to be able to incentivize the person to create more. Because only he has the rights to monetize, only he has the rights to benefit from fruits of his labor, right? Now, that isn't the case when you're talking of a non-human. In that case, then the basic premise on which our laws are drawn up sort of is shifting. And if that's shifting, then probably we shouldn't be using the same systems to look at something which is not on the same ground. It would be almost like comparing apples to, not even apples to oranges, but let's say apples to a mobile phone, because one is a product of a living thing and one is a non-living human invented product. So that is one that we need to answer. The other thing is, once we start answering and we answer with that premise in mind, I think then we are talking of wholly new systems. The whole process of evaluation the question will not be whether it should be territorial. The question will not be whether it should be jurisdictional. The question will not be whether we should give exclusive right. The question will not be, for example, many companies give, X number of years to human copyrighted works and are evaluating if for AI generated works, we can give a lesser number of copyright period. But I would say that that's not the answer to the solution. If instead of 60 years or 70 years, you're saying for AI copyright, we'll give 10 years, that's not the answer. Because then you're using the same framework to sort of just apply it forcefully to something which is not comparable. Right? So probably the need is to think totally out of the box. The need is to think outside the systems that are available and then come up with something more tangible and reasonable. And that should be trans borders, that should be trans number of years, trans authorship, trans inventorship, and so on. Because also the lines of authorship, inventorship, trademarks, logos, these lines are also blurring, especially with the kind of platforms that we have. Metaverse is just a platform that we have, right? It is a convergence of lots of technologies that are existing. It brings together copyrights, trademarks, patents, criminal issues, civil rights issues, human rights issues, because it's just a platform. It's kind of posing the same kinds of issues which many of us faced when the web world was growing, when the internet came up, right? How would we exercise our rights on the internet? Will we have similar rights there? How will we have criminal actions there? But we figured those out. And similarly, so, we need to think beyond platforms. We need to think about substantive underlying issues and how they are shifting ground rather than sort of trying to fit them in same frameworks. That's what I would think. But again, that's my personal view. I don't know how this evolves or, how this takes shape.
Thank you, Lakshika. I think there is no right and wrong answers to all of this. These are still, we are just attempting to crystal gaze in terms of how the laws will emerge and what are the possible solutions. And as you rightly said, I think a clear line of sight is yet to emerge while different courts across the world are dealing with these issues which are becoming more real now. Just as a concluding question, because we are running out of time, maybe this is a brief question for both you and Nayona. In terms of the cyber security and data privacy risks, right? How do you see that unfolding in the virtual space of metaverse?
I think metaverse is an extremely growing space, a dynamic space, and cybersecurity and data privacy issues will come up. While we say that it is anonymous, at the end of the day, you are feeding in your data and your PAN card and details to create your MetaMask wallet. And at the end of the day, if the government actually comes up with regulations for, how to deal with the taxation aspects, though some regulations have come in, but we need more clearer regulations. We will need to disclose certain things. So anonymity will not be completely achieved. It's going to be a misnomer. So I think cybersecurity, data privacy issues will obviously arise. It's just about how we continue to deal with them. As of now, it's of course, we'll have to interpret the existing laws, as Lakshika said, with the current situation. The existing laws are not made for the current situation. So it's the spirit of the law and the interpretation of statute that will have to be taken into account. But I'm sure with time, yes, it will evolve and we will have more regulated structures. So that's a parody as well, because the whole idea of Web3 is that it's unregulated.
Thank you, Nayona. Lakshika, any comments?
Yeah, Anubhav, I think as we are all aware, AI needs huge, humongous amounts of data sets to feed itself on. For one output, the neural networks, the way they work is they will have billions of data fed into it to achieve that one output. So I think in that situation, surely data privacy security issues will always be on top of everyone's mind, because it scrubs through a lot of data, it scrubs through a lot of data sets. Also, interestingly, not just privacy issues pertaining to individuals and how we protect data, but also whether the data sets that are being fed for these AI systems, how ethical those data sets are, how accurate those data sets are, because the more skewed these data sets are, the more algorithmic bias is what we'll get in our outputs. So I think that's also something that we need to be cognizant of.
Absolutely, Lakshika. I think we should. We are run out of time. Any questions from the audience? We'll be happy to answer.
Yeah, with reference to questions from the audience, we shall, send them across to your email, because looking at the fact that we are slightly, we have to keep pace with the
Okay.
time. Right. So thank you so much, Anubhav Kapoor. Thank you so much to Nayona Roy. Thank you so much, Lakshika Joshi ji. Very interesting session. Yes, indeed. Today, new technology, especially metaverse, have a very significant role, but one has to also look at the challenges and the related controversial aspects associated with them. Thank you so much. It was indeed a very great session. Thank you so much to all of you for joining us for this very special session.
Thank you. It was lovely
Thank
being
you.
here.
Thank you so
so
much.
much.
Thank
Thanks,
you.
Anubhav. Thanks, Nayona. Bye.
Thank you,
you.
Lakshika.
Bye-bye.
Thanks, everyone.